There we go. Got it. Okay, so freedom of speech and freedom of press. We're going to jump in and put both of these into the same column and category here. And so when we look at both of these topics, we'll come back, time permitting, and watch the video on freedom of press. If not, we may hit that another day. So as they mentioned, there's a number of limitations involved in freedom of speech. And we need to understand exactly what First Amendment is implying when it talks about this in Amendment number 1. It says, Congress shall make no law respecting an establishment of religion or, moving on here, abridging the freedom of speech or of the press. So we've already looked at that, and so you should be familiar with Amendment 1. There are a number of things that are protected here, that we are free to express our thoughts and express our speech. So verbal speech is typically what we think of, anything that we say and that comes out of our mouth. Written speech is also very important as well, that you can write, you have the freedom to write your thoughts. Pictures or images are also protected under this. And then symbolic speech. And this is where I want to spend a little more time today talking about symbolic speech or expressive conduct, the way that we are going to express ourselves through symbolism or through some sort of action. And so I brought up here the case United States versus O'Brien from 1968. And the situation here was that a man intentionally burned his draft card on the steps of the courthouse out in public as a way to make other people evaluate their opinions of the selective service or the military draft. And so he was doing this as an overt action to condemn the government, condemn the drafting system, and in a way to cause an uprising against that government's ability to institute the draft. And so when it went to the court and the Supreme Court evaluated this, they said that while he does have the freedom to make that action because it was with the intent of inciting a rebellion or to gain momentum against the government, that it was not protected under the First Amendment. And so the action there was struck down. He was not allowed to do that. When we look here at this one, Tinker versus Des Moines Independent School District, this one goes the opposite direction, where the action was allowed by the Supreme Court. So there are a group of students in this Iowa high school that decided they were going to wear black armbands throughout the school day to protest the Vietnam War. They were not trying to recruit or to condemn the government. They were just launching a peaceful protest here, and everybody wearing black armbands was identifying that they were against the idea of the Vietnam War. So the principal suspended them. He didn't like the way that this protest was going. Even though they were not doing anything violent, they got suspended from school. It goes all the way to the Supreme Court. Supreme Court rules, well, they were not doing anything that was going to be harmful or that was going to ignite any sort of conflict against the government there. Max?
But we couldn't do that here because this is a private institution, right?
So there are different rules under that, correct, because of the fact that we are a private institution. Now, he made the point in the video about how there's definitely a difference between private, he used businesses, and free speech and government agencies. So First Amendment protects you against the government action. So you could do that. We could suspend you from school or even expel you out of school, and it's not going to be upheld in the Supreme Court because of that fact. Now, if you go to private or public school, then rules are a little bit different there. Make sense? Yeah, good question. Good point there. So what I want you to understand here is that a lot of this has to do with the court's interpretation of what is the action meant to accomplish. Is it going to bring about more violence, or is it going to bring about a government rebellion? And that's really what they're trying to interpret, and that's why I gave you two different cases there in which the court ruled differently in both of those. And the intent of this in the Constitution is to protect unpopular expression. Just because people don't like what you're doing does not make it wrong or does not make it against the Constitution. So in more modern terms, we can use the Colin Kaepernick thing, which he still doesn't have a job, does he? Okay. So Colin Kaepernick choosing to sit down for the national anthem to protest even though we don't, well, me personally, I don't like that action, it's protected here under the Constitution. He's not trying to incite violence. He's not trying to attack the government. He is just voicing his opinion, even though it may be an unpopular one. So that's what it's intended to protect and why it's there. And again, we need to remember that no constitutional freedom is absolute, that there are limitations to all of that. So we begin here with some restrictions on our freedom of expression or freedom of speech, and one of those restrictions is an idea called sedition. So sedition is the act by which you are going to make an attempt to encourage other people to overthrow the government through violence. Could be through an action, could be through a letter, could be through a commercial, all kinds of different avenues that could come. And we have had a number of times in our government where we have passed sedition acts, 3 times in fact. 1789, that one expired, and so we renewed it in 1800. Where the government would not allow any of this type of speech to happen, and if they caught you, then they would throw you in jail. The first two there, 1789 and 1800, were both declared unconstitutional by our Supreme Court. And yet it was allowed to be passed then again in 1917, just around the time of World War I. And so it would make criminal certain things like encouraging people to be disloyal to our government. So under this Sedition Acts here, you couldn't go out and try to encourage people to get out of the military or for common citizens to support the other side of the war or even to criticize the government in some cases. If you were found writing a letter to the editor and you criticized the war effort, they potentially could come arrest you. Any sort of obstruction with the draft, any kind of insubordination or disobedience to our military, any of those type of things. So according to the language here in the Sedition Acts, they said any willful print, write, or publishing of disloyal, profane, they use the word scurrilous. That is a foreign word to me. Somebody wants to add that to your vocabulary. Or abusive language about the form of the government of the United States was under the Sedition Act. So the Sedition Act of 1917 was actually upheld by the court a number of times. And in the video, they talked about Schenck versus the United States in 1919. And this is the most notable of times where the Sedition Act was upheld and Mr. Schenck was not allowed to protest the draft. And so, we can see where the court has actually allowed for this to happen. And the Smith Act of 1940 technically still exists today. And this act made it a crime to advocate the violent overthrow of the government. Okay, so I would include that here in your notes just a little bit so that you know the Smith Act outlawed the encouragement of a violent overthrow of the government. And that's never been overruled and it's never been struck down. So therefore, it's technically still in existence. You can't organize a group that's going to try to overthrow a government. It's technically illegal. There it goes. Okay, so restriction number 2 is obscenity. Now, this one's a really difficult one because obscenity is a little bit hard to define. Yes, sir.
Back on the sedition.
Yep.
How does that relate to like when America was first declaring its independence from Britain, putting those restrictions on if the government is not abiding by the will of the people have the right to overthrow the government.
Yeah, that's a really great point. That's part of the reason why the Supreme Court declared the first two sedition acts unconstitutional. Um, I don't know, without further investigation, to understand how the 1917 Act was upheld, especially in Schenck versus United States, when you bring that point up. I'd have to do a little more digging and research to find out the rationale there. So I don't have a great answer for you, but that's a really great point because you're right. It's almost like we're being hypocritical to our original roots, considering that our nation started on the fact that we were disloyal and we were upset with our government. We very much proclaimed out against government. Yeah, good point. When we look at obscenity, the term that's been used, or the defining point here, is anything that could corrupt those whose minds are open to immoral influences. We really didn't have to deal with obscenity until 1815 was the first reported case that came to the courts, where somebody was upset about something that was printed or something that was said. So it's a really, really broad spectrum. A lot of times when we're dealing with obscenity, we're dealing with printed material, photos, digital media, that type of thing. Pornography would be included in obscenity. Also, certain language, cuss words, and those type of things would be considered here in obscenity. And so the courts have been really having a difficult time coming to a consensus, finding an objective term or objective definition of what obscenity is. And so it's often debated. And I could list for you a number of Supreme Court cases that have argued over this. I'm going to spare you from some of those, but just understand that it becomes very difficult to define. And many people have said, well, this is a expression of my personal opinions. It's a expression of my free speech. It's protected under Amendment 1. And others have argued, on the other hand, they've said, well, no, this is infringing on my rights. You are offending me by putting this out there, by me reading it, and therefore it shouldn't be allowed. And morally, unfortunately, many of these cases go in defense of the people that are producing the obscene material. Number 3 is fighting words. And again, our video talked a little bit about that and gave us some definitions to that, and I'm going to just hit on this briefly. So fighting words are any sort of words that are intended to inflict injury or incite violence. Just by the words that you say, you are trying to start up a fight. You are trying to get people angry enough to go to violence. So that'd be a technical definition of fighting words. Hate speech is typically directed toward a group. However, in its intention, it's not meant to bring about violence. So you may be throwing in there some racial terms, you might be throwing in there some religious bias, but you're not trying to start up something violent. That's how the courts are going to define and differentiate between the two, between fighting words and hate speech. So in the video, they used the example of burning crosses, which I hope does not come to your mind, as that's not something that you typically think of as a fun activity. So, just lost my connection here for a moment. There was a case in which this was brought up, and there was a cross-burning ban in the state of Virginia where you were not allowed to burn crosses. And I think we could understand why. But this goes all the way up to 2003. So within your lifetime, this one actually appeared before the Supreme Court. where they said this is a restriction on our freedom of expression and our freedom of speech. We should be allowed to burn crosses if we want to. And so this this comes out of the Supreme Court, and the Supreme Court decides that, well, as long as the cross burnings are not targeting certain individuals over others, that you're not being discriminatory in your cross burnings, then I suppose they're allowed. And so they had to strike down the law against cross burnings, and so it only outlawed cross burnings that were used for intimidation. Well, I can't imagine a cross burning that's not used for intimidation, but that's just me, and because of the connotation of it. So I don't know how they're going to get around that, but that's relatively new. Restrictions here on false statements. There are two major areas that you need to be familiar with, and you may already know what these are all about, but when it comes to libel and slander, so libel is talking about damaging speech that is published or printed. And so I'm going to ruin your reputation by printing a story about you that may be partially true or may be based on some facts, but I'm going to embellish it a little bit. And in some cases, it could be 100% factual, but it's written with the intent to damage your reputation. Charlie? Blackmail could be part of that, sure. Yeah. So I'm printing this to try to harm you in one way or another. So libel is printed form. Slander is going to be verbal. And so if I'm going to slander you, I'm going to give up and give a speech. I'm going to do an interview. I'm going to talk about you, and I'm going to reveal information that is going to damage your reputation. There was a case where the New York Times was sued for libel based on stories that were written about civil rights protests going on in Alabama. And they were criticizing the mayor for the events that were going on in this small town in Alabama. And the mayor goes to the New York Times and he sues them for libel. And the Supreme Court came back and they sided with the New York Times because the New York Times was printing factual information. They were talking about the rioting. They were talking about the protests that were going on. They were not trying to harm the reputation of that mayor. They mentioned him as the mayor, but they did not talk about him as being a terrible mayor, or they were not intentionally trying to ruin his reputation. And again, I could give you other cases where that has happened, but libel and slander still is a big one in our world today. Sometimes I wonder how some of the news channels don't get sued more often. Some of the stuff that they talk about. Another restriction is prior restraint. Historically, the Supreme Court has found that prior restraint is unconstitutional. And so I need to make sure we understand what prior restraint is all about before we move on here. It is the idea of the court system stopping material from publication or broadcast before it gets out there. Okay, so the Supreme Court is going to jump in. They're going to say, no, you can't print that or you can't put that over the airwaves because of the effect it's going to have. It might be libel, or it might be harmful to the country, it might be a national security risk. Now, there are some countries in our world that do this frequently, that every single news story that's published or put over the TV has to be screened through their government, excuse me. Our government has freedom of press, and therefore, typically this does not happen. So typically the Supreme Court is going to say that prior restraint, the government checking over all this stuff and stopping a story from getting published, is unconstitutional. However, there are some times where that can be enforced. One of the times here, the New York Times versus the United States in 1971, this deals with the Pentagon Papers, in which somebody got a hold of some secret classified documents regarding the Vietnam War. And these documents out of the Pentagon were not supposed to be revealed to the public. And if they had been revealed to the public, they would have been embarrassing to our government. It revealed some of the blunders that our military tacticians made. It also talked about some of the very big mistakes that we made in Vietnam. And so the Pentagon, specifically the Department of Defense, and the president went to the Supreme Court and said, we want prior restraint on this. Please don't publish this. It's going to really harm our effort in the Vietnam War. The Supreme Court said, sorry, government doesn't win on this one. And they allowed the Pentagon Papers to be published. And so sometimes that can go through, but typically prior restraint does not happen. There are a few times where prior restraint is upheld, especially when it is a national security risk. Certain CIA documents are, if they get leaked, they can be upheld by prior restraint. Typically, it has to do with national security issues, though.